shopping means, generally what it meant was help me get a record deal. That was sort of the overall idea of shopping. But what it also means is sort of packaging. It can mean other things. It can mean, hey, can you help me get a manager? Can you help me get a publishing deal? You know, it's something that, again, is not, you're shopping for third-party interest on behalf of the artist. You're trying to find somebody that will be interested in entering into some kind of business arrangement with the artist in the music business, like managers, like record companies, like music publishers. In the shopping situation, are the attorneys paid differently, really, for their services? And again, I don't do it, but I do know somewhat about it. And the answer is yes. Usually it does, because the attorney is risking and taking a lot of time and involving himself in the process. Excuse me. So it might take a couple of different forms. It might be, instead of an hourly rate, it might be the attorney might get some participation in the deal that the attorney is able to generate. It might be an ongoing percentage of the revenue received by the artist. That's sort of one style of shopping deal. It's like the attorney is still speccing his time, meaning the attorney's not being paid for that effort of trying to find the deal, but when the deal comes in, the attorney is going to be compensated for more than what the attorney actually spent. There's sort of the other side of the shopping deal, which is a little bit of the more unseedy side, and that is, you pay me X dollars and I'll go out and try to shop for a deal for you. So, you know, again, the attorney is being paid a flat fee regardless of what is generated. So again, subjectively, I don't like that, because I think it's unfair to the artist. And one of the reasons I don't shop, besides the fact that I said earlier, is that it's not really the practice of law, and besides the fact that it's sort of not really as relevant as it used to be in the music business, is that the structure, the fee structure doesn't work well for me. I don't like to charge an artist just for taking the time to make some calls or send some letters to a record company or a manager. Yet, I make a living as a music attorney, so I can't really devote time for free to try to get a deal for an artist that may never pan out. So that's just a third reason to say, you know what, if you get interest, I'll help you. If you've got a manager who wants to talk to me about who do I think is a good label, or if the manager has been contacted by a label, I'm happy to consult with managers or with artists about how that might work. But what is not a good situation for me is to just take the product and start flying it out there to labels who might be interested. I think it's much better suited for a manager when it's appropriate. I mean, I still think that you know, this is not really, again, an issue for practicing law, but it is a reality in the music business. An artist is better suited spending their time and money generating their product, spending money on PR, marketing, promotion, get out there and tour and make some noise, and then that often generates the interest. Then the phone rings. You don't actually have to take it and send it. I have, you know, real life experiences with artists or small record companies who have done that, just created the activity, and then the phone rings, because record companies, again, the A&R people are not sitting back and waiting for the next big thing to come in the mail. They're watching MySpace, they're watching sales, they're watching record store information. They have contacts in retail, they have contacts at radio stations, they have contacts who are promoters, and that's the sort of thing that is now generating the interest, or the interest to the record company to say, wait a minute, I see what's going on with this artist, I'm going to call them and find out what they're up to. So.